Hi, and welcome to the third episode of my vlog, Personal Injury Lawyer Tips. My name is Andrew Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll discuss what damage awards in the form of monetary compensation you may receive following a successful tort action. If you want to learn more about the 7 steps or primary stages in a tort lawsuit for personal injuries, if you've been injured in a motor vehicle accident in Ontario, then watch episode number 2 of my vlog called What Are the Steps in a Tort Lawsuit for Personal Injuries? Or read the blog of the same name. If your tort action against the at-fault driver in the Superior Court of Ontario is successful, then the most common remedy that the court will provide you is an award of damages for your losses. A similar word for damages is monetary compensation. In tort law, we classify damage awards in accordance with the specific purpose that they are intended to serve, which are 1, compensation, 2, punishment, and/or 3, vindication. However, compensatory damages is easily the most common damage award, especially in personal injury law cases, where you are seeking compensation for your losses already incurred in the past and anticipated in the future. Occasionally, you might be awarded aggravated damages, as well as punitive damages that are designed to punish the defendant. But it depends on whether, amongst other things, the conduct of the defendant was reprehensible. Furthermore, there is a high threshold for establishing a basis for an award for aggravated and punitive damages. The fundamental purpose of damage awards is to place you in the position you would have been, no better or worse, but for the at-fault driver's negligence. This fundamental primary guiding principle in tort law behind the awarding of damages in personal injury law cases is captured in the Latin term restitutio ad integrum, or restitutio in integrum, which means restoration to original condition. Since this goal is oftentimes not possible if your injuries and impairments were catastrophic, money is a barren substitute for health and personal happiness. The tort measure of compensatory damages may be described as the normal expectancies measure, a term which again more clearly describes the aim of awards of compensatory damages in tort, namely to reposition you to the destination you would normally have reached had it not been for the tort. The measure is objective, based on the evidence. This balance of compensatory fairness between you and a negligent at-fault driver is also expressed in these 2 legal principles and rules. 1, the thin skull rule, and 2, the crumbling skull rule. Further to the thin skull rule, the negligent at-fault driver is liable for your accident-related injuries and impairments, even if they are unexpectedly severe, owing to a pre-existing condition. So the negligent at-fault driver must take you, the victim, as he or she finds you, and is therefore liable even though your losses are more dramatic than they would be for the average person. However, it's balanced out by the crumbling skull rule, which recognizes that your pre-existing condition was inherent in your original position. Therefore, the negligent at-fault driver need not put you in a position better than your original position. If your action in tort is successful at trial, then the court will award you damages in a lump sum in order to ensure finality or a clean break between you and the at-fault driver. Due to the fact that your severe and permanent accident-related injuries will adversely impact several aspects of your life, there are several heads or types of compensatory damages that you may claim. One of the tort awards and damages you can claim is non-pecuniary damages or general damages, which would be awarded to compensate you for your pain, suffering, loss of enjoyment of life, and loss of amenities. However, you won't obtain non-pecuniary general damages unless you can prove that you suffered at least one of the following. 1, a permanent and serious disfigurement. Or 2, a permanent and serious impairment of an important physical, mental, or psychological function. The burden of proof is on you to establish, on a balance of probabilities, that you have suffered a permanent and serious impairment. Since a serious impairment is one that substantially interferes with your ability to function, you also have to prove at least one of the 3 following things. 1, your accident-related impairments substantially interfere with your ability to continue your regular or usual employment at your full-time or part-time job, despite reasonable efforts to accommodate your impairments and your reasonable efforts to use the accommodation to allow yourself to continue employment. 2, your accident-related impairments substantially interfere with your ability to continue training for a career in a field in which you were being trained before the incident, despite reasonable efforts to accommodate your impairment and your reasonable efforts to use the accommodation to allow yourself to continue your career training. And/or 3, your accident-related impairment substantially interfere with your ability to continue in most of the usual activities of daily living, considering your age. You also have to prove that your accident-related impairments are an important function to you, because the function is 1, necessary to perform the activities that are essential tasks of your regular or usual employment, taking into account reasonable efforts to accommodate your impairment and your reasonable efforts to use the accommodation to allow you to continue employment. 2, necessary for you to provide for your own care or well-being. And/or 3, important to your activities of daily living, considering your age. Also, you have to prove that your accident-related impairments, 1, have been continuous since the incident, and based on the medical evidence, and subject to your reasonably participating in the recommended treatment of the impairments, are expected not to substantially improve, as you're still suffering from it since the motor vehicle accident. And 2, are of a nature that is expected to continue without substantial improvement when sustained by persons in similar circumstances. In determining whether you have met the aforementioned legislative threshold, the court will answer the following 3 questions sequentially. 1, have you sustained a permanent impairment of a physical, mental, or psychological function? 2, if yes, then is your function, which is permanently impaired, an important one? And 3, if yes, then is the impairment of your important bodily function serious? In regards to question number 1, to be considered permanent, your impairment must be continuous since the accident and must, based upon medical evidence and you reasonably participating in recommended treatment of the impairment, not be expected to substantially improve. In regards to question 2, this part of the analysis is subjective and qualitative and asks whether your impaired function is one that is important to you, having regard to you as the whole. Here are 2 other questions that are asked as part of the analysis. 1, is the function necessary to perform the activities that are essential tasks of your regular or usual employment, considering reasonable efforts to accommodate you and your reasonable efforts to use that accommodation. And 2, is the function necessary for you to provide for your care or well-being, or important to your usual activities of daily living, considering your age? Each case will be as different as plaintiffs may enjoy different activities and interests and may have different employment. Lastly, in regards to question number 3, at this step of the analysis, the court will determine whether your permanent impairment of function is serious. An impairment is serious if it substantially interferes with your ability to continue your regular or usual employment, despite reasonable efforts to accommodate you, and despite your reasonable efforts to use the accommodation to allow yourself to continue employment. Alternatively, an impairment is serious if it substantially interferes with most of your usual activities of daily living, considering your age. In Canada, there's an upper limit or maximum amount that could be awarded to you in a tort lawsuit for non-pecuniary general damages. In 1978, the Supreme Court of Canada set a limit on monetary awards at $100,000. However, this limit has increased since then in accordance with the rate of inflation, and as of July 2022, it is $436,182. If a court determines that you don't meet the aforementioned legislative threshold test, then it will award you nothing for non-pecuniary general damages and healthcare expenses or costs of care, which will be discussed later in this vlog. Even if you meet the aforementioned legislative threshold test, there are automatic deductions on an award for non-pecuniary general damages, unless the award meets specific monetary thresholds. For example, since 2022, $41,503.50 will be automatically deducted from any award for non-pecuniary general damages unless your award equals or is greater than the 2022 monetary threshold of $138,343.86. Your rights to damages are subject to any apportionment of damages due to your contributory negligence, which would reduce the overall total amount awarded to you in damages. For example, if you were awarded $100,000 in total damages, but you were found to be 25% contributory negligent, then your total damages will be reduced by 25% or $25,000 down to $75,000. You could be found to be contributory negligent if, for example, you weren't wearing your seatbelt during the accident. When the court is deciding the award for non-pecuniary general damages to award you in a trial, it oftentimes refers to precedents or monetary awards made in factually similar cases to yours. Generally speaking, the more serious and permanent your impairment is, the greater impact on your ability to function in your overall daily life and or employment, the more you can expect a higher monetary award for non-pecuniary general damages. As the court is assessing the appropriate award to you, it will consider the following relevant, non-exhaustive factors. 1, your age. 2, the nature of your injury. 3, the severity and duration of your pain. 4, your disability. 5, your emotional suffering. 6, the impairment of your family dynamics, marital and social relationships. 7, the impairment of your physical and mental abilities. 8, your loss of lifestyle. And 9, your stoicism, which shouldn't penalize you unfairly. You may be awarded aggravated damages. which are rooted in an independent, actionable wrong committed by the defendant, are designed to compensate you specifically with a reprehensible or outrageous conduct on the part of the at-fault negligent driver causes you a loss of dignity, humiliation, additional psychological injury, or harm to your feelings. You may be awarded punitive damages, which are also rooted in an independent, actionable wrong committed by the defendant and are not designed to compensate you. Rather, the specific purpose of punitive damages is to punish the tortfeasor or negligent at-fault driver and deter future tortfeasors. The court may award you punitive damages if the negligent at-fault driver's conduct was malicious, reprehensible, oppressive, or high-handed. If you suffer a reasonably foreseeable, recognizable psychiatric illness, either as a direct result of being involved in the motor vehicle accident or being at the scene to observe the accident or its aftermath caused by the negligence of the at-fault driver, then the court may award damages to you for your psychological injuries. If you were to sadly die from a motor vehicle accident caused by the negligence of the at-fault driver, then your estate cannot claim for an award in damages for your untimely loss from a successful tort lawsuit. However, if you died or sustained a serious and permanent impairment or serious and permanent disfigurement, then your spouse, children, grandchildren, parents, grandparents, and/or siblings may claim for an award of damages. The award in damages that they could claim are as follows. 1. Actual expenses reasonably incurred for the benefit of either your injury or death. 2. Actual funeral expenses reasonably incurred. 3. A reasonable allowance for travel expenses actually incurred visiting you during your treatment or recovery. 4. Where, as a result of your injury, your spouse, children, grandchildren, parents, grandparents, and/or siblings provided nursing, housekeeping, or other services for you, a reasonable allowance for loss of income or the value of the services. And 5, an amount to compensate for the loss of guidance, care, and companionship that your spouse, children, grandchildren, parents, grandparents, and/or siblings might reasonably have expected to receive from you if your injury or death had not occurred. In 1992, the Court of Appeal for Ontario set the high-end range to be $100,000 for each of the parents of the deceased, which was deemed to be at the high end of an accepted range for loss of guidance, care, and companionship damages. However, in order to ascertain what the high-end range for non-pecuniary general damages is in current dollars, you simply have to figure out the cost in current dollars to buy a basket of goods and services that cost $100,000 in 1992 dollars, which factors in the rate of inflation. Even if you meet the aforementioned legislative threshold test, there are automatic deductions on an award for Family Law Act non-pecuniary general damages, unless the award meets specific monetary thresholds. For example, since 2022, $20,751.76 will be automatically deducted from any award for Family Law Act non-pecuniary general damages, unless your award is either equal to or greater than the 2022 monetary threshold of $69,171.36. Special damages are those damages that have manifested themselves prior to your trial and are therefore capable of precise calculation. Examples of special damages are, but not limited to, the following: hospital bills, lost wages, payment for housekeeping assistance, physician fees, etc. Pecuniary damages are any damages that are theoretically capable of monetary quantification, such as income loss, and they are considered separately from non-pecuniary general damages. You can also claim a monetary award for special damages for past expenses and losses caused by the negligence of the at-fault driver, which manifest themselves prior to trial and can therefore be calculated of accuracy and precision. Some examples are, but not limited to, the following. 1. Your past loss of income. 2. Your past loss of earning capacity. 3. Your cost of care, including medical and other healthcare expenses, assistance of self-care and supervisory tasks, assistive devices. 4. Your loss of housekeeping capacity. 5. Your past loss of pension income, contributions. And 6. Your expenses incurred by your family members, spouse, children, grandchildren, parents, grandparents, and/or siblings, to the date of trial following your death or injury. Any award for pecuniary damages in the form of either income loss or a loss of earning capacity between 7 days after the automobile collision and the start of trial, which is in excess of 70% of the gross income loss for accidents that occurred after September 1st, 2010, is deducted. So in Ontario, in addition to a legislative deductible of non-pecuniary general damages, if the legislative monetary threshold is not met, there is also a legislative deductible for a past economic loss tort award too. Another aspect of special damages that you can claim as an award is the cost of caring for you as a direct result of your injuries and impairments up to the date of your trial. Unlike an accident benefits claim, your cost of care can include care provided by a family member, as well as by a professional service provider. These services are inclusive of, but not limited to, the provision of housekeeping assistance and attendant care, as well as the cost of medical and rehabilitation treatment. Your award of special damages for costs of care may also be inclusive of out-of-pocket expenses and assistive and rehabilitative devices recommended by your healthcare providers, such as, but not limited to, canes, crutches, rollators to assist you with walking, support railings, etc. If you're unable to work as a direct result of your accident-related injuries and impairments, then it is likely that you will lose the pension contributions that your employer would have made on your behalf had you continued to work. So you could claim an award for special damages for the loss of your future pension income. If as a direct result of your accident-related injuries and impairments, you have lost the ability to function, to earn income, then you can claim an award of special damages for your loss of earning capacity and your loss of future income. Your claim for loss of earning capacity can be made even if you weren't working at the time of your motor vehicle accident. But I'll have to lead evidence on your behalf that establishes you would have obtained employment but for your accident. Your claim for a loss of earning capacity and a loss of income can also be inclusive of a loss of competitive advantage and a loss of opportunity, such as a delayed graduation, where I'd lead evidence to prove that there is a reasonable possibility that your loss will occur. You'll have to prove that you're no longer able to compete in the open marketplace with able-bodied and able-minded individuals who don't have accident-related injuries and impairments, but who have comparable qualifications or levels of skill, are capable of executing the tasks and duties required of the job, and may have additional certifications that you would have obtained but for your motor vehicle accident. Your inability to compete is the loss of an asset to you. In other words, your inability to freely compete in the open job marketplace for the type of work you would have competed for, but for your motor vehicle accident, is the asset that you have now lost. When a court quantifies your loss of competitive advantage, there are two popular methods that have been adopted, which are the traditional lump sum approach, without a specific regard to your calculated income loss, and the annualized income loss approach, where the award represents your annual income loss to an expected retirement date. When a court is considering the proper award for future damages, the Supreme Court of Canada stated that you're not required to prove on a balance of probabilities the probability of future damage, but rather you may be compensated if you prove in accordance with the degree of proof required in civil matters that there is a possibility or a danger of some adverse future development. So, the court will factor in varying degrees of probability of some adverse future development occurring, which will be balanced out by contingencies. As the court is ascertaining the appropriate value to assign to your future damage, since it doesn't have a crystal ball to gaze into the future to know what your future life would have been like but for the motor vehicle accident, it will factor in things such as, but not limited to, your projected level of earnings, the length of your working life, and positive and negative contingencies which might affect your future earnings. Factors affecting the degree of risk of your future economic loss and the possibility that all or part of these losses may have occurred apart from the wrong, which is the subject of the litigation, are referred to as contingencies. Some examples of contingencies which might affect your future earnings are, but not limited to, business depression, early retirement, illness, promotion, time off work due to pregnancy for women, unemployment, etc. It's important to remember that not all contingencies are adverse, as the examples I gave would appear to indicate. So the court will also factor in your rewards of fortune, too. The law has recognized that contingencies fall into two categories as follows. One, general contingencies, which is a matter of human experience or likely to be the common future of all of us. Example, promotions or sickness, etc. And two, specific contingencies, which are peculiar to you. Example, a particular marketable skill or a poor work record. If you are unable to complete the work you usually did within your household as a direct result of your accident-related injuries and impairments, then you can claim an award for special damages for your loss of housekeeping capacity. Concerning the issues that arise regarding pecuniary and non-pecuniary housekeeping losses, the Court of Appeal for Ontario has recognized 3 scenarios in which you will cope with your inability to complete your pre-accident housekeeping services. And they are as follows. 1, pretrial housekeeping left undone. 2, pretrial housekeeping performed inefficiently. And 3, pretrial housekeeping undertaken by third parties. Lastly, even though past pretrial loss of housekeeping capacity is a non-pecuniary general damage too, the court will not create a separate heading for it, but rather include it in its global assessment of all your non-pecuniary general damages. You can also claim an award of damages for your ongoing or future expenses and losses, which will either continue or be incurred after the date of your settlement or your trial. I would retain a forensic accountant to calculate with reasonable precision your expected future losses or extraordinary costs that will likely occur throughout your lifetime as a direct result of your accident-related injuries and impairments. Further to the Court of Appeal for Ontario, I only have to lead evidence to establish that there is a substantial possibility that your ongoing or future expenses and losses and damages will occur. Since your future damages will be paid to you as a lump sum at either your settlement or your trial, I will calculate on your behalf the present-day value of your anticipated ongoing or future expenses and losses. If as a direct result of your motor vehicle accident, you sustained a serious and permanent injuries and impairments, or a serious and permanent disfigurement, which requires ongoing and future care, then you can claim an award for future care damages that project the cost to provide you care, which wouldn't have been necessary but for the accident. In theory, your claim for the cost of future care is a pecuniary claim for the amount which may reasonably be expected to be expended to place you in the position you would have been if you had not sustained your accident-related injuries and impairments. When a court is deciding your future damages for costs of future care, it's essentially peering into the future and fixing damages for future care as best it can, once and for all at the time of your trial, subject to modification on appeal. In doing so, courts will rely on the evidence that I lead on your behalf as to what care is likely to be in your best interest. Then the court calculates the present cost of providing that care to you and may make adjustments for the contingency that the future may differ from what the evidence at trial indicates. Again, if a court determines that you don't meet the aforementioned legislative threshold test, then it will award you nothing for your health care expenses or cost of care. The Supreme Court of Canada made a distinction between the assessment of causation, which deals with the past, and contingencies, which deals with the future. Your past events, which comprise your special damages, must be proven, and once proven, they are treated as certainties. In your tort action, the court will declare whether the at-fault driver was negligent, and that conclusion cannot be couched in terms of probabilities. Likewise, the negligent conduct of the at-fault driver either was or was not a cause of your injuries and impairments. The court will decide on the available evidence whether the thing alleged has been proven. If it has, it is accepted as a certainty. However, when the court is assessing damages, which depend upon its view as to what will happen in the future, or what would have happened in the future if something had not happened in the past, the court will make an estimate as to what are the chances that a particular thing will or would have happened and reflect those chances, whether they are more or less than even in the amount of damages which it awards. If you want more information, then please read my blog of the same name called What Damage Awards Do I Get from a Successful Tort Action? In my blog, I go into much more detail in all of the heads of damages I mentioned in this vlog, as well as provide links to other blogs such as What Are the Steps in a Tort Lawsuit for Personal Injuries, which provide additional information you'll find helpful. I hope you found this information valuable. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my website at rudderlawgroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs with valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in episode 4 of Personal Injury Lawyer Tips. Well, I'll bring you more useful legal information.